A patent is a set of exclusive rights granted by a sovereign state to an inventor or assignee for a limited period of time in exchange for detailed public disclosure of an invention. An invention is a solution to a specific technological problem and is a product or a process. Patents are a form of intellectual property. The procedure for granting patents, requirements placed on the patentee, and the extent of the exclusive rights vary widely between countries according to national laws and international agreements. Typically, however, a granted patent application must include one or more claims that define the invention. A patent may include many claims, each of which defines a specific property right. These claims must meet relevant patentability requirements, such as novelty and non-obviousness. The exclusive right granted to a patentee in most countries is the right to prevent others from commercially making, using, selling, importing, or distributing a patented invention without permission. Under the World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights, patents should be available in WTO member states for any invention, in all fields of technology, and the term of protection available should be a minimum of 20 years. Nevertheless, there are variations on what is patentable subject matter from country to country. Definition: the word patent originates from the Latin fatere, which means to lay open. More directly, it is a shortened version of the term letters patent, which was a royal decree granting exclusive rights to a person, predating the modern patent system. Similar grants included land patents, which were land grants by early state governments in the USA, and printing patents, a precursor of modern copyright. In modern usage, the term patent usually refers to the right granted to anyone who invents any new, useful, and non-obvious process, machine, article of manufacture, or composition of matter. Some other types of intellectual property rights are also called patents in some jurisdictions. Industrial design rights are called design patents in the U.S., plant breeders' rights are sometimes called plant patents, and utility models and Gebrauchsmuster are sometimes called petty patents or innovation patents. The additional qualification utility patent is sometimes used to distinguish the primary meaning from these other types of patents. Particular species of patents for inventions include biological patents, business method patents, chemical patents and software patents. History: patents were systematically granted in Venice as of 1450, where they issued a decree by which new and inventive devices had to be communicated to the Republic in order to obtain legal protection against potential infringers. The period of protection was 10 years. These were mostly in the field of glass making. As Venetians emigrated, they sought similar patent protection in their new homes. This led to the diffusion of patent systems to other countries. The English patent system evolved from its early medieval origins into the first modern patent system that recognized intellectual property in order to stimulate invention. This was the crucial legal foundation upon which the Industrial Revolution could emerge and flourish. By the 16th century, the English Crown would habitually abuse the granting of letters patent for monopolies. After public outcry, James I of England was forced to revoke all existing monopolies and declare that they were only to be used for projects of new invention. This was incorporated into the Statute of Monopolies, in which Parliament restricted the Crown's power explicitly so that the King could only issue letters patent to the inventors or introducers of original inventions for a fixed number of years. The statute became the foundation for later developments in patent law in England and elsewhere. Important developments in patent law emerged during the 18th century through a slow process of judicial interpretation of the law. During the reign of Queen Anne, patent applications were required to supply a complete specification of the principles of operation of the invention for public access. Legal battles around the 1796 patent taken out by James Watt for his steam engine, established the principles that patents could be issued for improvements of an already existing machine and that ideas or principles without specific practical application could also legally be patented. Influenced by the philosophy of John Locke, the granting of patents began to be viewed as a form of intellectual property right, rather than simply the obtaining of economic privilege. The English legal system became the foundation for patent law in countries with a common law heritage, including the United States, New Zealand and Australia. In the 13 colonies, inventors could obtain patents through petition to a given colonia unregistered trademark legislature. In 1641, Samuel Winslow was granted the first patent in North America by the Massachusetts General Court for a new process for making salt. The modern French patent system was created during the Revolution in 1791. Patents were granted without examination since inventors' right was considered as a natural one. Patent costs were very high. Importation patents protected new devices coming from foreign countries. The patent law was revised in 1844, patent cost was lowered and importation patents were abolished. The first Patent Act of the U.S. Congress was passed on April 10, 1790, titled An Act to Promote the Progress of Useful Arts. The first patent was granted on July 31, 1790 to Samuel Hopkins for a method of producing potash. Law, effects: a patent does not give a right to make or use or sell an invention. Rather, a patent provides the right to exclude others from making, using, selling, offering for sale, or importing the patented invention for the term of the patent, which is usually 20 years from the filing date subject to the payment of maintenance fees. A patent is a limited property right the government gives inventors in exchange for their agreement to share details of their inventions with the public. Like any other property right, it may be sold, licensed, mortgaged, assigned or transferred, given away, or simply abandoned. A patent, being an exclusionary right, does not necessarily give the patent owner the right to exploit the patent. For example, many inventions are improvements of prior inventions that may still be covered by someone else's patent. If an inventor obtains a patent on improvements to an existing invention which is still under patent, they can only legally use the improved invention if the patent holder of the original invention gives permission, which they may refuse. Some countries have working provisions that require the invention be exploited in the jurisdiction it covers. Consequences of not working an invention vary from one country to another, ranging from revocation of the patent rights to the awarding of a compulsory license awarded by the courts to a party wishing to exploit a patented invention. The patentee has the opportunity to challenge the revocation or license, but is usually required to provide evidence that the reasonable requirements of the public have been met by the working of invention. Enforcement: patents can generally only be enforced through civil lawsuits, although some countries have criminal penalties for wanton infringement. Typically, the patent owner seeks monetary compensation for past infringement, and seeks an injunction that prohibits the defendant from engaging in future acts of infringement. To prove infringement, the patent owner must establish that the accused infringer practices all the requirements of at least one of the claims of the patent. An accused infringer has the right to challenge the validity of the patent allegedly being infringed in a countersuit. A patent can be found invalid on grounds described in the relevant patent laws, which vary between countries. Often, the grounds are a subset of requirements for patentability in the relevant country. Although an infringer is generally free to rely on any available ground of invalidity, some countries have sanctions to prevent the same validity questions being relitigated. An example is the UK Certificate of Contested Validity. Patent licensing agreements are contracts in which the patent owner agrees to grant the licensee the right to make, use, sell, and/or import the claimed invention, usually in return for a royalty or other compensation. It is common for companies engaged in complex technical fields to enter into multiple license agreements associated with the production of a single product. Moreover, it is equally common for competitors in such fields to license patents to each other under cross-licensing agreements in order to share the benefits of using each other's patented inventions. Ownership: in most countries, both natural persons and corporate entities may apply for a patent. In the United States, however, only the inventor, may apply for a patent, although it may be assigned to a corporate entity subsequently, and inventors may be required to assign inventions to their employers under an employment contract. In most European countries, ownership of an invention may pass from the inventor to their employer by rule of law if the invention was made in the course of the inventor's normal or specifically assigned employment duties, where an invention might reasonably be expected to result from carrying out those duties, or if the inventor had a special obligation to further the interests of the employer's company. The inventors, their successors or their assignees become the proprietors of the patent when and if it is granted. If a patent is granted to more than one proprietor, the laws of the country in question and any agreement between the proprietors may affect the extent to which each proprietor can exploit the patent. For example, in some countries, each proprietor may freely license or assign their rights in the patent to another person, while the law in other countries prohibits such actions without the permission of the other proprietor. The ability to assign ownership rights increases the liquidity of a patent as property. Inventors can obtain patents and then sell them to third parties. The third parties then own the patents and have the same rights to prevent others from exploiting the claimed inventions, as if they had originally made the inventions themselves. Governing laws. The grant and enforcement of patents are governed by national laws, and also by international treaties, where those treaties have been given effect in national laws. Patents are granted by national or regional patent offices. A given patent is therefore only useful for protecting an invention in the country in which that patent is granted. In other words, patent law is territorial in nature. When a patent application is published, the invention disclosed in the application becomes prior art and enters the public domain in countries where a patent applicant does not seek protection, the application thus generally becoming prior art against anyone who might seek patent protection for the invention in those countries. Commonly, a nation forms a patent office with responsibility for operating that nation's patent system, within the relevant patent laws. The patent office generally has responsibility for the grant of patents, with infringement being the remit of national courts. The authority for patent statutes in different countries varies. In the UK, substantive patent law is contained in the Patents Act 1977 as amended. In the United States, the Constitution empowers Congress to make laws to promote the progress of science and useful arts. The laws Congress passed are codified in Title 35 of the United States Code and created the United States Patent and Trademark Office. There is a trend towards global harmonization of patent laws, with the World Trade Organization being particularly active in this area. The TRIPS agreement has been largely successful in providing a forum for nations to agree on an aligned set of patent laws. Conformity with the TRIPS agreement is a requirement of admission to the WTO, and so compliance is seen by many nations as important. This has also led to many developing nations, which may historically have developed different laws to aid their development, enforcing patents laws in line with global practice. In addition, there are international treaty procedures, such as the procedures under the European Patent Convention, constituting the European Patent Organization, that centralize some portion of the filing and examination procedure. Similar arrangements exist among the member states of ARIPO and OAPI, the analogous treaties among African countries, and the 9 CIS member states that have formed the Eurasian Patent Organization. A key international convention relating to patents is the Paris Convention for the Protection of Industrial Property, initially signed in 1883. The Paris Convention sets out a range of basic rules relating to patents, and although the convention does not have direct legal effect in all national jurisdictions, the principles of the convention are incorporated into all notable current patent systems. The most significant aspect of the convention is the provision of the right to claim priority. Filing an application in any one member state of the Paris Convention preserves the right for 1 year to file in any other member state, and receive the benefit of the original filing date. Another key treaty is the Patent Cooperation Treaty, administered by WIPO and covering more than 140 countries. Application and prosecution. A patent is requested by filing a written application at the relevant patent office. The person or company filing the application is referred to as the applicant. The applicant may be the inventor or its assignee. The application contains a description of how to make and use the invention that must provide sufficient detail for a person skilled in the art to make and use the invention. In some countries there are requirements for providing specific information such as the usefulness of the invention, the best mode of performing the invention known to the inventor, or the technical problem or problems solved by the invention. Drawings illustrating the invention may also be provided. The application also includes one or more claims that define what a patent covers or the scope of protection. After filing, an application is often referred to as patent pending. While this term does not confer legal protection, and a patent cannot be enforced until granted, it serves to provide warning to potential infringers that if the patent is issued, they may be liable for damages. Once filed, a patent application is prosecuted. A patent examiner reviews the patent application to determine if it meets the patentability requirements of that country. If the application does not comply, objections are communicated to the applicant or their patent agent or attorney through an office action, to which the applicant may respond. The number of office actions and responses that may occur vary from country to country, but eventually a final rejection is sent by the patent office, or the patent application is granted, which after the payment of additional fees, leads to an issued, enforceable patent. In some jurisdictions, there are opportunities for third parties to bring an opposition proceeding between grant and issuance, or post-issuance. Once granted, the patent is subject in most countries to renewal fees to keep the patent in force. These fees are generally payable on a yearly basis. Some countries or regional patent offices also require annual renewal fees to be paid for a patent application before it is granted. Costs: the costs of preparing and filing a patent application, prosecuting it until grant and maintaining the patent vary from one jurisdiction to another, and may also be dependent upon the type and complexity of the invention, and on the type of patent. The European Patent Office estimated in 2005 that the average cost of obtaining a European patent and maintaining the patent for a 10-year term was around £32,000. Since the London Agreement entered into force on May 1, 2008, this estimation is however no longer up to date, since fewer translations are required. In the United States, in 2000 the cost of obtaining a patent was estimated to be from $10,000 to $30,000 per patent. When patent litigation is involved, costs increase significantly. While 95% of patent litigation cases are settled out of court, but when the case reaches the court, direct legal costs of patent litigation are on average in the order of $1 million per case, not including associated business costs. Alternatives to applying for a patent: a defensive publication is the act of publishing a detailed description of a new invention without patenting it, so as to establish prior art and public identification as the creator-originator of an invention, although a defensive publication can also be anonymous. A defensive publication prevents others from later being able to patent the invention. A trade secret is information that is intentionally kept confidential and that provides a competitive advantage to its possessor. Trade secrets are protected by non-disclosure agreements and employment law, each of which prevents information leaks such as breaches of confidentiality and corporate espionage. Compared to patents, the advantages of trade secrets are that the value of a trade secret continues until it is made public, whereas a patent is only in force for a specified time, after which others may freely copy the invention. Does not require payment of fees to governmental agencies or filing paperwork. Has an immediate effect. And does not require any disclosure of information to the public. The key disadvantage of a trade secret is its vulnerability to reverse engineering. Economics. Rationale: primary incentives embodied in the patent system include incentives to invent in the first place, to disclose the invention once made, to invest the sums necessary to experiment, produce and market the invention, and to design around and improve upon earlier patents. Patents provide incentives for economically efficient research and development. A study conducted annually by the IPTS shows that the 2,000 largest global companies invested more than €430 billion in 2008 in their R&D departments. If the investments can be considered as inputs of R&D, real products and patents are the outputs. Based on these groups, a project named Corporate Invention Board had measured and analyzed the patent portfolios to produce an original picture of their technological profiles. Supporters of patents argue that without patent protection, R&D spending would be significantly less or eliminated altogether, limiting the possibility of technological advances or breakthroughs. Corporations would be much more conservative about the R&D investments they made, as third parties would be free to exploit any developments. This second justification is closely related to the basic ideas underlying traditional property rights. In accordance with the original definition of the term patent, patents are intended to facilitate and encourage disclosure of innovations into the public domain for the common good. If inventors did not have the legal protection of patents, in many cases, they might prefer or tend to keep their inventions secret. Awarding patents generally makes the details of new technology publicly available, for exploitation by anyone after the patent expires, or for further improvement by other inventors. Furthermore, when a patent's term has expired, the public record ensures that the patentee's invention is not lost to humanity. In many industries, once an invention exists, the cost of commercialization is far more than the initial conception cost. Unless there is some way to prevent copies from competing at the marginal cost of production, companies don't invest in making the invention a product. One effect of modern patent usage is that a small-time inventor can use the exclusive rights status to become a licensor. This allows the inventor to accumulate capital from licensing the invention and may allow innovation to occur because he or she may choose not to manage a manufacturing build-up for the invention. Thus the inventor's time and energy can be spent on pure innovation, allowing others to concentrate on manufacturability. Another effect of modern patent usage is to both enable and incentivize competitors to design around the patented invention. This may promote healthy competition among manufacturers, resulting in gradual improvements of the technology base. This may help augment national economies and confer better living standards to the citizens. The 1970 Indian Patent Act allowed the Indian pharmaceutical industry to develop local technological capabilities in this industry. This act transformed India from a bulk importer of pharmaceutical drugs to a leading exporter. The rapid evolution of Indian pharmaceutical industry since the mid-1970s highlights the fact that the design of the Patent Act was instrumental in building local capabilities even in a developing country like India. Criticism. Legal scholars, economists, scientists, engineers, activists, policymakers, industries, and trade organizations have held differing views on patents and engaged in contentious debates on the subject. Recent criticisms primarily from the scientific community focus on the core tenet of the intended utility of patents, as now some argue they are retarding innovation. Critical perspectives emerged in the 19th century, and recent debates have discussed the merits and faults of software patents, nanotechnology patents and biological patents. These debates are part of a larger discourse on intellectual property protection which also reflects differing perspectives on copyright. See also, Glossary of patent law terms, List of patent-related topics, List of people associated with patent law, references. External links, Directory of Intellectual Property Offices, maintained by World Intellectual Property Organization, useful links, maintained by the European Patent Office, OECD Patent Statistics, Henderson, David R. Patents. Concise Encyclopedia of Economics. Library of Economics and Liberty OCLCA 317,650,570, 50,016,270 and 163,149,563.